Hi there. I found an interesting article in my news feed last night that concerned a case that just came out in Alberta regarding family law. Not very often the family law cases attract headlines, but in this case it did. And my take on it was, how far will a woman go in family court to get the children, get money, whatever it is that she's looking for? So the decision from the Court of Queen's Bench in Alberta was just released yesterday. The decision came down on August 25th, 2020. The case I'm referring to is AVI versus MHVB and Jacqueline Robinson, aka Jacquie Phoenix. I'm going to put a link in the description for those wanting to read it. The mother had taken the child to the US and refused to return her. Authorities were involved, and the child returned to Canada under the father's primary care, with restrictions on the mother and grandmother's access to the child. The mother is facing criminal charges. Does the mother realize that she's made a big mistake? Maybe take the advice of a lawyer on how to rebuild her case to get some parenting time with her daughter? Nope. Instead, she fires all her lawyers in her family case and her criminal case. She doesn't even go down the self-represented path that so many out-of-control exes do. Oh no, she goes full-on blow up your own chances in your legal case mode. Ms. Robinson presented herself to the court as the legal representative for the mother in this case. She has no legal training. She is not recognized as a lawyer anywhere in Canada. Specifically, she's not licensed to practice law in Alberta. Ms. Robinson is a front person for what is known in the Alberta court as an organized pseudo-legal commercial argument, or OPSA group. As Justice Graesser points out in his judgment, or in his decision, I guess I should call it, this is the third incarnation of this pain in the judicial system to rear its ugly head in the past few decades. They changed the name, maybe a few concepts, twist a new sort of legal premise, and proceed to challenge any authority over them and their supporters. Not once have they ever succeeded. Not a single parking ticket, fine, family hearing, criminal trial, or any legal event has ever been successful with their pretend law. Yet people blindly accept that they can win against the court and the government with these ridiculous mumbo-jumbo words and concepts which have zero meaning in Canada, England, or the Commonwealth. The OPSA in this case is known as the Magna Carta Lawful Rebellion Scheme, or MCLR, as Justice Graesser named it. In his decision, he goes into some detail to outline the scheme and how it plays out in court. Indeed, in his decision, paragraphs 37 through 104 outline the details of how this all plays out. Essentially, this group believes that Article 61 of the Magna Carta has been invoked and therefore the Queen and Court have no standing. Mrs. Robinson likes to use big words, which she clearly does not understand for meaning and context, and it gets her nowhere fast. The premise of Article 61 is that a group of barons can rebel against the Crown and seize certain assets if the Crown commits an act of treason. At no point does Article 61 apply to a person, whether king or commoner, and certainly not to children. The MCLR based their existence on a letter to the Queen in 2001 regarding the Treaty of Nice, which was concerning the UK's participation in the EU. Pardon me. The Magna Carta was a document drawn up in 1215 by barons in medieval England to curb the power of King John. A year later, in 1216, King John was dead and his son Henry III was on the throne. That same year, 1216, the Magna Carta was drastically changed and Article 61 disappeared. There were more revisions of the Magna Carta until 1297, and none of them included anything like Article 61. Today, only 3 articles remain of the original document that still apply in English law. In Canada, they don't exist at all after we became independent of the UK in 1982. The three articles that remain are Article 1, which recognizes the immunity of the Church of England. Article 9 grants the City of London its ancient liberties. And Article 29 recognizes the right of free men, or men who are not serfs, shall not be infringed except by legal processes. The MCLR adherent swears allegiance to a UK noble person pursuant to Article 61 of the Magna Carta of 1215. In this case, they say they have sworn an oath to Baron Craigmile of Inverness-shire, and this is in paragraphs 134 to 136 of the decision. You have to feel for this man, as he has no idea, pardon me, that all of these letters of people swearing an oath to him are then using it as a means to illegally act in his name. Justice Graesser issues a clear warning to the Baron to distance himself from the group. And when you're making your first communication to a court, I would think that threatening an Associate Chief Justice and a Justice with the gallows if they don't return the property of the child is not exactly going to win over your audience of that same justice or your case for you. At paragraph 6 of the decision, Justice Graesser gives us the transcript or the letter that he was first sent regarding this case. It says, "Dear Robert A. Graesser, this is to inform you that MHVB is lawfully standing under Article 61 of the 1215 Magna Carta, which was invoked on March 23, 2001, according to Constitutional Royal Protocol. The Court of Queen's Bench is an unlawful assembly with no authority to deal with this matter. Since the invocation of Article 61, thus all judgments made by the Court of Queen's Bench in this matter are null and void. MHVB and all of her property are protected by the Constitution and the people of the Commonwealth realm. We require the immediate restoration of her property, see the enclosed Exhibit G in the Notice of Conditional Acceptance. Failure to restore the property of MHVB within 7 days of receiving this letter will constitute as high treason, which still carries the gallows. I urge you to consider Eichmann versus the people, quote, I was just doing my job, unquote, is no defense, Nuremberg. Maxim in law, ignorance of the law is no excuse. Sincerely, Jacquie Phoenix." Exhibit G that she has mentioned is listed as MHBV's purported property. It's a photo of a 4-year-old girl, presumably her daughter. The group's Facebook page is heavily monitored for comments and criticism, which are quickly deleted. Among the comments remaining are such things as common law and constitutional law cannot be changed. Given the common law is judge-made law, and it's a body of law that has developed over the centuries in English law based on judges' findings. So it's constantly undergoing change as new findings are made in the courts every day. Constitutional law can, of course, be changed and has evolved over time as the law is tested against new cases. The comments that are allowed to stay up are blind acceptance to the tenets of the group, and nobody is asking if their law has actually worked in a real court. As a lawyer, I get asked all the time by clients about success based on our legal argument in case law, which is also known as common law in the real legal world. Why won't the group answer that same question? The three big takeaways from this decision of Justice Graesser is, 1, Ms. Robinson has a very skewed view of history and no understanding of how the law evolved. She has no concept of the Magna Carta and that most of it no longer applies to the law in the UK, let alone the independent state of Canada. She has no understanding of the history upon which she stands. And I say this with a master's degree in historical archaeology, specifically of the developed world. Number 2, Ms. Robinson is dangerous because she is willing to put a child-parent relationship in jeopardy for her own gain. The OPCA followers have lost their children because they are seen as unable to parent with the best interests of the child in mind. Just being a member of an OPCA can have you declared an unfit parent. To OPSA, children are considered property to do with as they please. And yes, some of the cases in the criminal system are quite disturbing. Our own Supreme Court of Canada has shut down the notion of children being property hard. Number 3, what people like Ms. Robinson are missing is probably the most important flaw in their arguments. They go to a court they believe is part of some big tyranny and conspiracy, but they expect relief from that same venue. They want a decision from our court, even though they say they don't recognize it. If the courts were in fact part of tyranny, they would not grant the relief to someone who's attempting to usurp them. In fact, a tyrannical judicial system would likely send people like Ms. Robinson to the gallows for treason. Ms. Robinson and the parties have until September 30th to submit their positions. Unless Ms. Robinson can come up with a very solid, valid legal argument, she's facing being banned from, according to paragraph 120, providing legal advice, preparing documents intended to be filed in court for any person other than herself, and filing or otherwise communicating with any Alberta court except on her own behalf. And she will be banned from acting as an agent, next friend, Mackenzie friend, from Mackenzie and Mackenzie 1970, and the Alberta Rules of Court, and Alberta Regulations 124/2010, sections 2.2 to 2.23, and any other form of representation in court proceedings. If Ms. Robinson continues her actions in the judicial system using OPCA strategies, she can also have consequences such as court costs, court access restrictions, contempt of court proceedings, and criminal proceedings. All of these can involve money, they can involve her going to jail, they can involve her being detained by being picked up by the police until the next court hearing that's available for her. To use a legal phrase, govern yourself accordingly, Ms. Robinson and your followers.